La Cour.
Please be seated. I declare open the public hearing on the admissibility in the case of Ukraine versus Russia, re Crimea. The application number 20958/14 was lodged with the court on 13 March 2014 under Article 33 of the Convention by the government of Ukraine. The application was allocated to the third section of the court pursuant to Rule 51, Paragraph 1 of the Rules of Court. On 13 March 2014, the President of the third section decided to apply Rule 39 of the Rules of Court, interim measures. He called upon both the high contracting parties concerned to refrain from taking any measures, in particular military actions, which might entail breaches of the Convention rights of the civilian population, including putting their life and health at risk, and to comply with their engagements under the Convention, notably in respect of Articles 2 and 3 of the Convention. The same day, it was also decided to give the case priority under Rule 41 of the Rules of Court. The application was communicated to the respondent government on 20 November 2014. In January 2016, the application was assigned to the first section of the court. On 26 August 2015, another application, application number 42410/15, was lodged with the court under Article 33 of the Convention by the government of Ukraine. That application was first assigned to the third section and subsequently to the first section of the court. It was communicated to the respondent government on 29 September 2015. On 7 May 2018, the Chamber decided to relinquish jurisdiction of the two applications in favour of the Grand Chamber. On 11 June 2018, the two applications were joined under Rule 42, Paragraph 1 of the Rules of Court, and given the new name Ukraine versus Russia, re Crimea, under the case number 20958/14. The respondent government are represented by their agent, Mr. Mikhail Galperin, representative of the Russian Federation at the European Court of Human Rights and Deputy Minister of Justice of the Russian Federation. He is assisted by Mr. Michael Swainston, QC, Counsel, as well as by the following persons as advisors: Mrs. Yana Borisova, Mr. Pavel Smirnov, Mr. Edward Harrison, Mr. Vasily Torkanovsky, Mrs. Sofia Sarenkova, Mr. Vadim Zapivakim, Mr. Grigory Prozukin, Mrs. Maria Zinoveva, Mrs. Alana Syukaeva, Mrs. Ksenia Soloveva, Mr. Yevgeny Trunov, and Mrs. Valeria Grishchenko. The applicant government are represented by their agent, Mr. Ivan Lishina, Deputy Minister of Justice and agent before the European Court of Human Rights. He is assisted by Mr. Ben Emerson, QC, Counsel, as well as by Mrs. Mariarita Sokorenko, Mr. Dmitry Petrishin, and Mr. Andriy Luksha, advisors. I welcome the representatives of the parties in the name of the court. I would explain that in addition to interpreting in the two official languages of the court, English and French, interpreting into Russian has been authorized for the benefit of a group of lawyers and law students from Lviv National University attending this hearing. This interpretation is not part of the official interpretation of the proceedings as organized by the court. Having consulted the agents of the applicant and the respondent governments, I have determined the order of addresses as follows. Mr. Galpering and Mr. Swainston for the government of the Russian Federation will speak first, and then Mr. Lishina and Mr. Emerson for the government of Ukraine. I call Mr. Galpering.
Thank you, Mr. President, honorable judges. I'm in an unusual situation today while being a respondent and, however, pleading first, according to the direction of the court. So I will have to present the argument in response of the Ukrainians' claims without them being made public here first, but I sincerely hope that still our position will be clear nevertheless. Ukraine's written submissions is defective in many ways. The first main defect that the Ukraine application is a political application and not a bona fide application under Article 33 of the Convention. It talks about human rights, but much of its focus on the manner in which Crimea joined the Russian Federation in 2014. A second fundamental defect is that Ukraine's application is based for the most of propaganda instead of proper direct evidences. And that means that Ukraine has not satisfied the requirements for the prima facie proof of administrative practice referred by the court in its question to the parties before. Mr. Swainston QC will shortly amplify these points, and for my part, I wish to lay before this court essential arguments which demonstrate why that case is false in relation to Russian effective control. I anticipate that the representative of the applicant government will again allege today that Russia exercised effective control in Crimea from late February 2014, that Russia committed violations of the convention in Crimea amounting to administrative practice, that Ukraine's application is admissible and supported by reliable evidence. All these statements are groundless. Ukraine's keystone argument is that the Russian Federation has exercised effective control over Crimea from 27th of February 2014. And what's the legal basis for this? This principal way that Ukraine may put extraterritorial control is on the basis of a Lashko line of reasoning in this court's practice. But applicant has forgotten the essence of Ilashko cases. That cases show that support only carries control where that alleged support helps the local administration to resist the efforts of a lawful central government to restore the rule of law and democratic values. That line of reasoning from the Transnistrian cases does not apply here. First, the new Ukrainian government was not constitutional. It was installed by violence and replacement of the elected president in direct breach of Ukrainian constitution, since the only lawful means for replacing President Yanukovych would have been his own letter of resignation, his death, or impeachment. Nothing like this happened. Secondly, the new Ukrainian government was not democratic. Senior positions in the government in 2014, including the Minister of Defense, went to the fascist Svoboda party, which had polled only 10% in the preceding parliamentary elections, and to the right sector, which had never collected a single vote from anybody ever. Thirdly, this newly installed government was not trying to promote democratic values and rule of law. On the contrary, its installation gave rise immediately to a massive anti-Maidan movement, but wherever people objected, they were met with violence from the new government and its nationalist supporters. Call to mind resistance to the new government, new anti-constitutional government in Odessa, Nikolaev, Kherson, Dnipropetrovsk, Zaporozhye, Donetsk, Lugansk, Kharkov, and Crimea itself. People throughout Ukraine since 2014 faced limitations of their rights to speak their own language, to practice their religion, to meet their relatives from other side of the border, to express their thoughts freely. It has nothing in common with the rule of law and democratic values. So the court has no evidence before it that brings this case within the Ilashku line of authority of effective control. Aside from this argument, Ukraine has nothing in terms of direct control, just saying that there were some Russian forces in Crimea. But what did Russian forces do in Crimea? Not much, almost nothing. Their presence may have deterred a bloody intervention by the nationalists from the mainland Ukraine, but deterrence is not control. By deterring violence, Russian soldiers did not exercise any control or jurisdiction over anybody. However, by doing nothing, they did achieve something very important. They protected the convention rights of freedoms of expression that the new authorities in Kiev would shortly attack in East Ukraine. The Ukrainian government failed to present before this court any proof that Russian military servicemen had been involved in any of the human rights violations or that the local authorities and civil defense forces were somehow subordinated to them. Also, I would like to underline that moral support does not create control. I would remind the court that some Council of Europe countries, including Denmark, Germany, and the United Kingdom, followed the United States of America and declared recently that they officially recognized an opposition politician in Venezuela as interim president. Are these European countries take responsibility by that under the Convention for any incident happening in Venezuela due to their support of opposition there? To turn again to the court's effective control criteria, could you imagine that this so-called Venezuelan president will exist without, and I quote from the Catan decision, military, economic, and political support from these countries? Clearly no. Someone could still believe that the concept of effective control is intended to avoid a vacuum in the system of human rights protection in Europe. But due to its controversial character, all of the court's judgments which established effective control and use this concept do not bring any protection or relief to alleged victims and only make the relevant political process between the countries more complicated. There is the same risk here. Ukraine refers to the strengthening of the military presence of the Russian Federation in Crimea in February 2014, which it considered to be illegal. To be sure, the issues of lawfulness or unlawfulness of the military forces in Greece fall outside the scope of the Convention and the jurisdiction of this court. Nevertheless, I would respectfully draw the attention of the judges to the following points. It is essential to remind that, pursuant to the 1997 agreement between Russia and Ukraine on the Black Sea Fleet, the total military personnel strength of the Russian fleet on the territory of Crimea shall not exceed 25,000 personnel. So two countries come to an agreement many years ago that the presence of this number of military personnel would not affect the sovereignty of Ukraine and its jurisdiction in Crimea. Even this limit was not reached in March 2014. According to Ukraine itself, Russian military presence in Crimea never exceeded 22,000 people before reunification, and actual confirmed figure is 12,000 by March 21st, and it is less than 1% of the total peninsular population. There was also no requirement under the agreement for Ukraine's prior approval of changes, so the Russian forces were legitimately present by agreement with Ukraine. At the same time, it is difficult anyway for Ukraine to rely on this mere presence of the Russian forces also because it had substantial forces of its own in Crimea exactly at the same time. By its own Ukrainian officials' admission, Ukraine had more than 20,000 armed military personnel there until the very date of reunification and after this date. To try to satisfy the requirement of attribution of alleged human rights breaches to Russian state agents, Ukraine also refers to the public statements made by Russian President Mr. Putin. So if Ukraine pays so much attention to the words of the President of the Russian Federation, then the applicant government should have referred to all public statements made by Mr. Putin about the aims and the actions of the Russian military forces in Crimea at the material time. In his numerous interviews, the President explained that when a violent overthrow of constitutional government occurred in Ukraine, the Russian military was strengthened in Crimea on lawful ground, according to the agreement. The starting actions for Russia in that situation was an unconstitutional takeover in Kyiv. It was to increase its military presence to ensure the protection of Russian military forces and objects. The President emphasized on many occasions that the Russian presence ensured that the Crimean population could make a democratic choice safely without fear of reprisal from the radicals. This was inevitable when you take into account the commands that came out of Kyiv in that time, when one remembers Mr. Oleg Tigniboks, the head of the Svoboda party, who calls to drown Crimea in blood, and it was supported by Mr. Vitaly Klitschko, who was also the leader of the government in that time. It becomes clear why fear grew in Crimea and transformed into a move for separation from the new unconstitutional authorities in Kyiv. These fears come true for 48 innocent people burnt in Odessa in May 2014, and for thousands and thousands of Russian-speaking citizens of Ukraine killed in Donbass. Indeed, Russian servicemen did not affect the choice made by the people in Crimea. This choice was free. It is the government in Kyiv, installed by violence, largely drawn from neo-Nazi groups, that was the reason for political moves for the plebiscite in Crimea in 2014. That did not entail acquisition of any control of Crimea by Russia or any potential Russian responsibility for events there prior to 18th of March 2014, when Crimea became the part of Russia. This statement is also supported by the noticeable evolution of the referendum questions and modalities in Crimea between 27th of February and 7th of March 2014. The proposed date of the referendum gradually shifted from the 25th of May to 30th of March, and then to the 16th of March. The initial proposed agenda of referendum didn't include options for Crimea leaving Ukraine and acceding to Russia, but only returning the autonomy that Crimea had before within Ukraine. However, I would say that in February 28th, Vladimir Konstantinov, the president of the local parliament, also stated that no decision is possible on disintegration of Crimea from Ukraine. It was made on 28th of February. So it was only on 6th of March 2014 when the Crimean parliament, elected in 2010 under Ukrainian law and headed by Mr. Konstantinov, who also became the president of the parliament in 2010, decided to introduce such options. This evolution was a direct reaction of the people and authorities of Crimea to the way that events unfolded in Kyiv, not in Moscow, and the rising threat of violence happening in Ukraine. It clearly proves that it could not be any initial Russian plan to reunify with Crimea. It is Ukrainian new authorities which from day to day pushed their own citizens aside. Ukraine assumes that it lost its control of Crimea on 26th or 27th of February 2014. Russia did not take control either at this time or later before 18th of March 2014, and the true position is as follows. On 22nd of February 2014, there was a violent overthrow of constitutional government in Kyiv supported by Western countries. That caused immediate dissent entirely in Crimea and other parts of Ukraine. The physical threat posed by the new unconstitutional government and its paramilitary proxies led to the formation of the local civil defense forces in Crimea. The overall situation also led to local political moves by the people in Crimea when they organized the referendum for becoming the part of Russia. So what could be said about Russian effective control if most of the officials in legislative, executive, and judiciary institutions in Crimea appointed in compliance with Ukrainian laws remained fully functional in accordance with those laws up until 17th of March 2014. As for the appointment of the 27th of February of the new chair of the Ministerial Council, it was done by the legitimate Crimean parliament and agreed under Ukrainian law by the acting president Yanukovych. Perhaps the applicant's representatives could explain why Ukraine's central government tried to dissolve the Crimean parliament only on March 15, if it considered Crimea under effective control of Russia from the end of February. Also, how it is that when the Central Election Board in Kiev officially addressed Mr. Konstantinov and Crimean Parliament on 13 April 2014 regarding Crimean participation in Ukrainian general presidential election, so considering them in that time to be the part of Ukrainian state system. To summarize, Ukraine without any doubt remained responsible for all events in Crimea until reunification on 18th of March 2014. All authorities in Crimea continued to be regarded as authorities of Ukraine until that day, though becoming less and less responsive to the signs of Ukraine's new government in Kiev. Ukraine made no express derogation from these convention obligations in respect of that period and its territory. The threat of violence and violence of intervention led to a political response by the local authorities in Crimea and the holding of the referendum on 16th of March 2014 on whether Crimea should continue with Russia or with Ukraine. The referendum and the reunification cannot be seen in isolation. They were the direct result of the violent displacement of the constitutional government in Ukraine and rise of fascist groups in the country. Therefore, as regards the court's question whether it has jurisdiction to rule on the events before 18th of March 2014, the answer is no. As for the events after 18th of March 2014, the Russian government states that from these days, Russia exercised full territorial jurisdiction in Crimea under Article 1 of the Convention. But any attempts to examine the grounds of that jurisdiction are of speculative nature and fall outside the scope of the present proceedings. Along with that, the mere fact that Russia has jurisdiction in Crimea after the material date does not give legal basis to the jurisdiction of this court to examine the present case on the merits, since Ukraine failed to submit an admissible application with reliable evidence. Realizing that, the applicant government decided to change its tactics. Having failed to submit reliable evidence after all these 5 years, the Ukrainian government essentially attempts to replace in the last minute its own application by the report of the Office of the United Nations High Commissioner for Human Rights. Instead of submitting an exhaustive position on the admissibility of the case, Ukraine made extensive reference to these reports. The Russian government were deprived of any opportunity to submit in writing their comments on the latest observations of the applicant government, and so this hearing was presented as the only way to do so. Therefore, I find it necessary to explain before this court why the report may not serve as evidence in the present case. In particular, as it follows from the report, there was no fact-finding mission in Crimea during its preparation. No one from the working group visited Crimea. This fact itself raises serious doubts as to the reliability of the information presented in the report. The report contains serious accusations of human rights violations. However, given the lack of access to primary evidence, it is not clear at all how may the authors of the report allege a violation of, for example, the right of fair trial. What fact or document served as a basis for such a far-reaching conclusions about fair trial in Crimea? Similarly, the allegations that, and I quote, multiple and grave violations of the rights to physical and mental integrity have been committed by state agents of Russia in Crimea since 2014. And this is definitely absurd. Again, did the working group request and receive this information from the state officials about the investigation of these facts? Did the authors of the report meet the asserted victims in person? Understanding the facts of the report is particularly important. The report does not contain details. There are no names of the alleged victims. There is no information about the circumstances in which these violations allegedly occurred, and are they exactly violations of human rights? Therefore, this report may serve perhaps for political debates, but not for the aims of the establishment of legal facts. Another aspect that I'm going to touch is the witness statement which were collected by the office of my respected colleague, Ukrainian representative at the European Court of Human Rights. No reason were given as to why these explanations were obtained only 3 years after the events complained, since, however, their application was filed in 2014. So why no primary pieces of evidence were collected when these applications really lodged? Whether these explanations may be assessed as credible given the period of time lapsed from 2014. If during this hearing Ukraine is going to refer to the fear of prosecution as the explanation of keeping silence about these facts during these 3 years, then it should also clarify where these witnesses lived during this period. So if they returned to Ukraine in 2014, then what were the reasons for the fear of prosecution and why Ukraine couldn't provide them necessary legal protection? It is also not clear why these witnesses preferred to submit the information about the alleged violation of the convention to the state official who is not competent to investigate and remedy their situations. In this context, I would respectfully remind that in interstate cases, both parties are governments. There is no weak party in terms of collection of evidence and burden of proof. Hence, Ukraine is an applicant, has to prove today all its allegations properly. There can be no excuses for failure to do so, and the burden of proof cannot be shifted to the respondent government as it could be in individual cases. It means that by accepting this application, the court will put its admissibility and evidentiary standards for interstate applications to an unprecedented low level. Should Ukraine's application be stripped from generic, vague, and unsupported allegations of human rights violations, there will be not much left. Only pure politics will remain. But questions of sovereignty and political relations between the states are not convention questions. Ukrainian government in recent years attempt to use as many forums as it can, throwing complaints around and hoping that their political statements will acquire a legal meaning somewhere. Targeting Russia has become part of Ukraine's oligarchs' business and of the strategic litigation for the Ukrainian state and its allies. This court should not encourage these dishonest and bad faith tactics, which underestimate the standards and the role of the European Court of Human Rights. Accepting that Ukraine's application will also open a Pandora's box. If this case is accepted as admissible, new political sensitive cases will come to this court and will obstruct the functioning of the system of the Council of Europe. Instead of promoting the dialogue and encouraging further steps to stop the confrontation and ensure human rights protection in real life for real people in Russia and in Ukraine. This application, filed on behalf of the Ukraine in 2014 by the unconstitutional government in the period of severe crisis, should not be allowed to prejudice current efforts in better relations. It has no genuine human rights focus and could hugely damage the international consensus on which the real work of the courts depends. This concludes my submission. Thank you, and Mr. Swensson will now explain further defects of Ukrainian application.
Thank you very much. I call Mr. Swensson.
Mr. President, honourable members of the Court, the representative of the Russian Federation has explained why Ukraine's application is a political one and why the Russian Federation had no effective control in Crimea before the 18th of March 2014. Because of what happened in Kiev, the displacement of constitutional government and the installation of an unrepresentative, unconstitutional government, Ukraine has felt a propaganda imperative to blame Russia for what happened in Crimea and indeed for what happened in East Ukraine. The political focus is obvious. Just in Ukraine's December 2018 submission, we have mention of the referendum in Crimea 58 times. And we can see that, by contrast, Ukraine's evidence, so-called evidence, on alleged human rights abuses is secondary and weak. Ukraine's application is all about repeating its propaganda on political issues which are well outside the jurisdiction of this court. It is not a genuine application within Article 33. Now, Russia accepts the potential jurisdiction of the court from the 18th of March 2014, but the court would only have jurisdiction over a proper application, and Ukraine's applications are not proper. Aside from being overwhelmingly political, Ukraine's applications fail to satisfy the the admissibility criteria. And the only excuse is a constantly evolving allegation of administrative practice. Ukraine wants to rely on the suggestion in Georgia against the Russian Federation, 1, that the admissibility criteria may not apply if the object of the application is to draw attention to an administrative practice without calling for findings in individual cases. But there are problems with this approach. The first is Article 35(1) of the Convention, which states unequivocally that the court, this court, can only deal with the matter after domestic remedies have been exhausted, according to generally recognised rules of international law, and within a period of 6 months from the date on which the final decision was taken. These are mandatory requirements expressly agreed in the Convention between the Russian Federation and Ukraine and between all signatory states. What's more, they're reflected in the court's own rules. Rule 46 stipulates that a valid application by a state has to include a statement on compliance with these admissibility criteria. So it would be very odd indeed if Ukraine were allowed to avoid these criteria just by some vague allegation of administrative practice. It would also be totally unworkable. The suggestion is that instead of complying with admissibility, you can put forward an allegation of practice without seeking findings in individual cases. But how can this court find a practice without looking carefully at the facts of each alleged violation? How can this court find identical violations without looking at the violations to see whether they actually occurred and to see whether they're identical? How can the court find complicity of the respondent state without examining the facts of each case to see if the respondent state's agents were involved in the event? And fundamentally, Unless this court looks at each allegation carefully, how can it protect itself against political cases based on propaganda instead of evidence? This court is not a court of first instance. It doesn't have resources for extensive evidence hearings. The only safeguard against political cases comes in the admissibility criteria, because they require fact-finding by a domestic tribunal within a reasonably prompt time after the alleged violation. So the first point is that the Russian Federation respectfully objects to any abandonment of the admissibility criteria agreed as mandatory in the Convention. And this should not be controversial. In the Copenhagen Declaration of April 2018, the signatory states affirmed the importance of the admissibility criteria. We've provided for you some speaking references, and page 6 is the extract from the Copenhagen Declaration. At paragraph 32, the conference welcomed the court's strict and consistent application of the criteria concerning admissibility and jurisdiction, including by requiring applicants to be more diligent in raising their convention complaints domestically. It would be totally inconsistent with the convention and with that consensus amongst the constituents of this court to ignore the admissibility criteria. But if it were possible to substitute administrative practice, it would at least be necessary to comply with what the court has said about practice. First, Ukraine would need to plead and prove some clear practice. The first element of that is repetition of acts, and the court has said that there has to be an accumulation of identical or analogous breaches which are sufficiently numerous and interconnected to amount not merely to isolated incidents or exceptions, but to a pattern or system. Next, Ukraine would need to attribute the administrative practice to agents of the Russian Federation. And third, it would have to prove now both the practice and attribution to a prima facie degree. And Ukraine has totally failed to do any of these things. First, it doesn't even allege a clear practice. It alleges a range of violations from kidnapping to nationalization which have nothing in common. The victims have nothing in common. Sometimes they're said to be Tatars, sometimes they're said to be Ukrainians, sometimes they're said to be journalists. There is no case of repetition of identical breaches as part of a pattern or system. Second, Ukraine has failed to show attribution. For the most part, the perpetrators are said to be an unknown group of persons or an unidentified group of armed men or men in uniform. Usually, Ukraine blames members of Crimea's self-defense units, but there's no evidence that Crimea's self-defense units were directed in any way by the Russian Federation. So we have random allegations of breach of the Convention and no clear attribution of the alleged breaches to Russian state agents. There is an exception on attribution. Ukraine says that on the 18th of March 2014, a Russian sniper shot a member of Ukraine's armed forces when a military base was allegedly taken over. But that's hopeless on every level. First, it's an example of an isolated incident, no practice. Second, it never did happen, and Ukraine's evidence before you today doesn't go close to showing prima facie proof. There's a single statement from a Mr. Get. He's a member of Ukraine's security services. He simply asserts that the shooter was a sniper, and he blames Russia. Ukraine's submission in March 2017 said Ukrainian authorities obtained information, but it seems not to have been obtained by Mr. Get, and he says nothing about getting it. So this statement is second-hand, anonymous assertion. It doesn't even qualify as hearsay. Now, the context makes the propaganda obvious. That very day, the 18th of March, President Putin made a speech about how peaceful reunification had been. Russia had no incentive for violence. The only interests served by any provocation were those of the new Ukrainian government. The sniper allegation illustrates a problem with Ukraine's case as a whole. It doesn't meet the test laid down by the court in Georgia 1, but also the Commission in France, Norway, Denmark, Sweden and the Netherlands against Turkey. It is not substantial evidence. It doesn't substantively demonstrate the practice which is now alleged. Indeed, what do we have? We have statements from people like Mr. Gett, who are not there and not in a position to know anything. We have random statements about isolated incidents that don't show practice. And then we have vague and general allegations of administrative prejudice rather than administrative practice against various groups, be they Tatars, Ukrainians or journalists. And this is not good enough. Unless this court brings a proper content to the prima facie evidence requirement at this stage, there will be more political cases like this which take the court from its proper business and serve no useful purpose. If Ukraine had a genuine case, there would be lots of statements from victims alleging identical breaches. There'd be lots of direct evidence that they complained to the authorities and that didn't do any good. There would be lots of complaints that they went to court and they were refused a remedy for no good reason. It's important that you see this absence of evidence in the context of what is a propaganda campaign. And I'm going to show you, just in the speaking references, a taster of the evidence that you will see in response to Ukraine's case on East Ukraine, because it's easy, clear and visible. If you go to page 7, you have a picture of a soldier, Mr. Tarasov, supposedly from his social media, standing on one vehicle in a column of armoured vehicles, BTRs. I'm sure they can. They should have been. I'm sorry. If you go to the next page, page 8, we have another version of the same picture. One is the Atlantic Council. The other is Bellingcat. And I invite you to spot the difference. The difference is that the number on a vehicle in the column has disappeared. And that's because Bellingcat likes to say that the Russian government removes numbers before military vehicles go into Ukraine. If you go look at the next page, page 9, you can see a close-up. And on the right, you have the soldier's boots who's sitting on the vehicle next to the number. And right beside them in the metal, the number has disappeared. And we can see that that's been done by cloning the soldier's boots. And that tells us a number of things. First, this is very sophisticated. This doesn't show up under conventional computer forensic tests. So it's been done with artificial intelligence, but it's been done by a human being who perhaps wasn't quite so intelligent, and we see the propaganda. I point that out because you should be in no doubt that enormous resources have been deployed on producing fake evidence against Russia in these applications by Ukraine. You see the resources from page 10 and 11 of the handout. They show that just between the UK and the US, there were 650 people engaged in producing material for deception and propaganda in 2013, the time of our events, just before. And if you look at page 14, you can see Who pays the piper in relation to this fake evidence? Along the top, you've got consistent and recurrent funders. The US government, Mr. Soros and his Open Society foundations. Interestingly, we also see the Dutch government, which featured in the recent Georgia case, where there was a Dutch government inquiry which alleged a missile attack on the basis of what Russia demonstrated was fake video evidence. For today's purposes, note that the same sponsors financed the NGOs relied upon for administrative practice in this case. You see the money funneling down to a range of entities which further disseminate it to entities relied upon for evidence. The common factor behind these internet NGOs is bland objects that usually include strategic litigation, like what is happening today. They add their names to secondary allegations of prejudice or administrative practice against Tatars or Ukrainians or journalists. They print their logos on reports like Peninsula of Fear that Ukraine relies on as evidence. But fourthly and crucially, there's no evidence that they actually do any underlying evidence collection of primary evidence, and you don't see the sources in their reports. That goes for the expert evidence before you as well. Mr. Bushenko of Ukrainian Helsinki is financed in his task by the US State Department. He supposedly does research in briefers, which are published on the internet, it's said, but if you go to page 15 of your handout, you see what you regularly get when you look for the briefers. Sorry, the page you are looking for does not exist. Ms. Tomac is there as an expert, but she doesn't meet any requirement of apparent objectivity. She previously worked, in effect, for NATO in its Democratic Initiatives Foundation, which campaigned for Ukraine's membership of NATO. The Crimean Field Mission for Human Rights, that bears the logos of these internet NGOs, again, with no evidence that underlying research has been done. Ukraine was evidently sensitive to this when it prepared its December 2018 submission, which is why, as the representative has noted, it switched to the report of the UN Human Rights Commissioner. That is unsatisfactory in a number of respects. One is that in a reply submission, it tries to expand Ukraine's case by a further 2 years. The court has kindly suggested that I reply to it now. Unfortunately, half an hour with not a lot of time, I can't do it justice. I will say this, that it would be a denial of natural justice if the court placed any weight on allegations after Ukraine's second application. And I would also note that the change is cosmetic. The Human Rights Commissioner has relied upon Ukrainian Helsinki, and therefore Mr. Bushenko, paid by the US State Department. It relies upon the internet NGOs, Almenda, set up by Olga Skripnik, the Crimean Human Rights Group, also set up by Olga Skripnik. The researcher on the Human Rights Report appears to have worked for the Disability Rights Fund in Boston, USA. Interestingly, that fund in Boston, USA, is financed by Mr. Soros and the United Kingdom government. So again, there are issues with the objectivity behind these secondary statements of what has happened in Crimea. These connections would be unsatisfactory for an expert. They're also unsatisfactory for some kind of commentator, especially one who fails to identify sources or details. And when we look at Ukraine's own examples, they disprove any practice, at least on the part of the Russian government. Mr. Akhmetov is probably the most serious case on which Ukraine relies. He was taken off the street, it's said, and murdered, having been tortured. It's said there wasn't an investigation, but if you look at the handout, page 20, you see that the Russian authorities in Crimea sought assistance from Ukraine. It was a full investigation, hundreds of forensic tests, hundreds of witness interviews, but a key piece of evidence was what telephones had been used in the area where Mr. Akhmetov's body was found. Critical forensic evidence. And you see there Ukraine's reply. The requested assistance cannot be provided. There's no explanation at all, but perhaps the court can ask my learned friend why Ukraine complains today about a failure to investigate murders when Ukraine itself obstructs the relevant investigations. Now, consider the case of Mr. Alisov and his 2-year-old grandson, who were found drowned. This is said to be a murder of Tatar people. But the materials put before you for this hearing show that there was an investigation. The man and child died because part of a dam had collapsed and they fell into the river. Criminal proceedings followed against an engineer who worked on the dam, and they failed because causation couldn't be proved for criminal purposes. Now, this was a tragedy without question, but the real facts show two things. First, no violation of convention rights by Russia, and second, the callousness of those responsible for this strategic litigation by Ukraine, because they're quite willing to use an appalling incident like that to support a false allegation as a platform for saying administrative practice. On a lighter note, Ukraine also relies on the supposed disappearance and presumed killing of a Mr. Asanov. Happily, from documents provided by the Russian Federation, you will have seen that he's alive and well. He turns out to be an official in the office of the Ukraine's public prosecutor. He's a good citizen and he pays his taxes to this day. So again, this shows no administrative practice except Ukraine's practice of making up cases and evidence to support administrative practice. And I remind the court with respect that these are Article 2 allegations, the most serious. Now, what could possibly explain this carelessness? There is a natural explanation, and it's the one that the representative started with and that I started with. This case is not about human rights. These secondary allegations of administrative practice are there for jurisdictional reasons, and the human rights allegations are window dressing for a political case. And we can see against the background of these inadequate individual allegations why Ukraine is relying on secondary evidence instead of the evidence that the court should expect if Ukraine had a real case. Where are the primary witness statements? Where do the witnesses directly speak of lots of the same breaches? Where do we see them bouncing off investigative authorities or failing to get relief from courts? There's no evidence of proper, direct quality in respect of those matters. Now, consequences flow, we say, from this inadequacy of evidence. Ukraine needed administrative practice to justify an interstate application, even under Georgia against the Russian Federation 1. It needed administrative practice to try to overcome the admissibility criteria, an obvious hurdle. Without administrative practice, even on the court's most generous precedent, this case must fail because Ukraine has failed to comply with the mandatory admissibility criteria under Article 35(1). Of course, if there are proper individual complaints, they can proceed, subject, of course, to the admissibility criteria. And you may have noticed that Mr. Bushenko, put forward here as an expert, was lawyer for various of the individual applicants who feature in individual instances relied on by Ukraine. So Ukraine is duplicating individual applications for no good reason, except as indicated, to get through the admissibility criteria and to dress up a political case. We say that whilst individual applications may be possible, this court must make clear on this interstate application that political applications are not possible. This court must insist on a proper test at this stage. Yes, it's prima facie evidence, but it has to be substantial. It's got to be real. And we know that evidence of that quality is direct evidence. You should not get through to present a political case on the basis of secondary, unsourced statements. And it's unsafe to rely upon NGO reports or upon reports of the UN High Commissioner, who's relied upon such NGO reports to meet that test. Unless we see the primary evidence, there is no basis for finding that the prima facie test has been met, and there is no protection against political cases. Those are my submissions.
Thank you very much. According to long-standing practice of the Court, when only admissibility is at stake, as it is the case today, the respondent government speaks first and the applicant government follows. I call Mr. Lishina.
Mr. President, judges of the Court, I am grateful for this opportunity to introduce Ukraine's submissions on behalf of my government. As the Deputy Minister of Justice, I have had personal conduct of these proceedings, and I am therefore in a position to explain Ukraine's reasons for bringing this interstate litigation before the Court. The human rights violations alleged in these proceedings were committed against Ukrainian citizens on Ukrainian soil by the agents of a foreign power that has illegally occupied part of Ukraine's sovereign territory for the past 5 years. The government of Ukraine has an obvious duty towards these people to ensure that it has done everything possible to protect them. Each individual victim has suffered their own injustice. But when the totality of these individual violations is viewed together, it is possible to see the emergence of pattern or system. As the pieces are put together, the picture which emerges is one of the politically motivated repression targeted at certain vulnerable groups. Those groups include ethnic Ukrainians, who made up 24% of the population of Crimea before the Russian occupation, and ethnic Tatars, who made up 12% of the population at the time. They also included members of the Ukrainian military, pro-Ukrainian political activists, independent journalists, and religious leaders whose faith did not conform to the beliefs of the Russian Orthodox Church. They are a diverse collection of people, but they all have one thing in common. They are either actual or perceived opponents of the Russian occupation. It was, of course, open to the victims themselves to bring individual applications to this court complaining about what had happened to them, and some people have done so. But an interstate application is the only way of presenting the overall pattern of political persecution and the wholesale violation of civil and political rights of those who are seen to oppose Russia's illegal occupation. Far from protecting the rights of these minorities, as it is legally obliged to do, Russia has engaged in a deliberate campaign of political persecution aimed at eliminating all opposition. At the same time, it has encouraged the commission of grave human rights violations and fostered a culture of violence, intimidation, harassment, and impunity, amounting to an administrative practice of the Convention violations. According to the Court's case law, one of the central objectives of the Court's jurisdiction to rule on the existence of an administrative practice is to enable an applicant state to invoke the Court's jurisdiction with the aim of bringing the administrative practice to an end. An interstate case is the only means at Ukraine's disposal to achieve this. If the Russian government wants to call that a political motive, then so be it. But let me make one thing clear. When these proceedings began, it was far from obvious that the Court would necessarily be called upon to rule on the legality of the Russian occupation. But Russia itself put that question firmly in issue by denying that it has exercised extraterritorial jurisdiction for the violations committed before its illegal annexation of Crimea, and by asserting territorial sovereignty in respect of the violations committed afterwards. It is Russia's stance that has made a ruling on this question inevitable. Mr. President, judges of the Court, the United Nations and other international institutions have already condemned this ongoing pattern of political persecution and human rights violations targeted against opponents of Russia's unlawful occupation of Crimea. But these interventions have not so far succeeded in bringing the violations to an end. An administrative practice is ongoing to this day. Only a ruling from this Court on the merits of an interstate complaint is capable of doing that. This, I hope, explains why Ukraine has found it necessary to invoke the Court's jurisdiction in this way. With that introduction, I will now give floor to Mr. Emerson, who will make further submissions in support of the government of Ukraine's case.
Thank you. I call Mr. Emerson.
Mr. President, members of the Court, this interstate case concerns a pattern of human rights violations that are alleged to have been committed by agents of the Russian state and their proxies in Crimea during the military coup that took place in February 2014 and the unlawful occupation which has followed ever since. The victims included members of the Ukrainian military, political activists and journalists, as well as members of the Crimean Tatar and the ethnic Ukrainian communities. Mr. Swainston asked, what's the pattern? What's the unifying feature? Well, members of the Court, as the Deputy Minister for Ukraine has already said, the pattern is in the nature of what the victims and the targets all have in common. Because the targets of Russia's campaign of human rights violations and persecutions have one thing in common. They were all actual or perceived opponents of Russia's illegal occupation. In reports published in 2007 and now more recently in 2017 and 2018, the UN High Commissioner for Human Rights, as you have heard, records compelling evidence of a pattern of violations that included extrajudicial executions, enforced disappearances, arbitrary arrests, arbitrary searches of private property, all aimed at perceived political opponents of the Russian occupation. And contrary to what has been said to you this morning, reading the reports, it will be immediately apparent to you the extraordinary care, month-by-month regular reporting that the Office of the High Commissioner has engaged in, and a methodology that insists that allegations are only recorded if they have been directly interviewing the witness and if the witness's testimony is both corroborated and independently verified. So with the greatest of respects to the way in which Mr Swainston has tried to muddy the waters this morning, that report is an absolutely crystal clear condemnation and indictment of a Russian persecutory policy aimed against certain minorities. And overall, the UN assesses that there has been a dramatic worsening of the human rights situation in Crimea since the Russian occupation began, together with a serious accountability vacuum in relation to human rights violations, specifically those committed against dissenters by the security forces and other pro-Russian elements in Crimea. Based on regularly monthly reporting of the Human Rights Monitoring Mission in Ukraine established by the OHCHR under the authority of the United Nations Human Rights Council, the High Commissioner encapsulated the position in 2018, reviewing a consistent series of reports that began in March 2014. So the reporting period covers 2014, that's the date of the coup, right the way through to 2018. The High Commissioner's overall conclusion, I'll just read it to you, was this: grave human rights violations affecting the right to life, liberty and security have not been effectively investigated by the Russian Federation. The judiciary has failed to uphold the rule of law or to exercise the proper administration of justice. There is, said the High Commissioner, an urgent need for accountability for human rights violations and abuses, and providing victims with redress. That perhaps gives some explanation for why this case is before this court this morning. In 2014, the year of the coup, the Council of Europe Commissioner for Human Rights heard evidence of grave human rights violations targeted at dissenters, together with a deliberate policy of intimidation and harassment of journalists, activists, ethnic Ukrainians and Tatars. He confirms in his findings, and his report is available to you, he confirms the UN High Commissioner's conclusion that there was a prevailing culture of impunity for serious politically motivated crimes that had been reportedly committed by Crimean paramilitaries for whom, we respectfully submit, Russia is answerable. And in 2016, the Parliamentary Assembly of the Council of Europe adopted a resolution recording many of these human rights violations as findings of fact, and expressing the ominous conclusion that the level of discriminatory repression in Crimea had by then become so serious that it threatened the very existence of the Tatar community as a distinct ethnic, cultural and religious group. It threatened the very existence. It doesn't take a comment from me to remind the court what those words are referring to. These are serious and credible allegations which require a thorough examination on their merits, and as I'm going to show in the course of my submissions, the evidence establishing this pattern of persecution is more than sufficient to cross the admissibility threshold required at this stage of an interstate case. So let me turn to the court's questions, starting with the issue of jurisdiction. From Ukraine's perspective, there is no jurisdictional dichotomy between the period before Russia's illegal annexation, the 18th or the 21st of March, they're not quite sure when it is, but one of those dates anyway, and the period since then. There's no jurisdictional dichotomy because the legal basis for Russia's Article 1 jurisdiction it has remained the same throughout. Ever since the military coup, Russia has been exercising extraterritorial jurisdiction for the purposes of Article 1 of the Convention. That is based on Russia's effective overall control of a portion of Ukraine's sovereign territory. Russia is legally answerable in this court for the pattern of human rights violations, not as the territorial sovereign, but as an occupying power, and that remains the position to this day. So the first question that the Court is called on to decide at this stage of the proceedings is whether there is at least prima facie evidence that Russia was in effective overall control of Crimea during the period between the 27th of February and the 18th or 21st of March, whichever date Mr. Swainson happens to be choosing on any particular day. We say it is obvious that Russia took effective control over Crimea when it mounted the military coup on the 27th of October of that year. That was the purpose, the intended purpose of the military coup, and that was its result. The evidence shows that there were significant covert and unauthorised troop deployments in the weeks leading up to the 27th of February, but on the day of the coup itself and the days which followed, Russia's troops openly flooded into Crimea by land, by air and by sea. They seized control of Crimea's semi-autonomous parliament. They dismissed its Council of Ministers and they set up a puppet regime in its place. They disabled and then disarmed the Ukrainian military, and they blocked the deployments of reinforcements from the Ukrainian mainland. The operation as a whole was carefully planned and centrally coordinated. It was put into effect in the very early hours of the morning on the 27th of February, with the first troop movement starting shortly after 4 o'clock. Russian forces, operating with the paramilitary forces of the Crimean Self-Defense Forces, the so-called CSDF, surrounded Ukrainian military installations, including naval and air force bases. They took strategic positions blocking access to ports and airports, and they stationed powerful military deployments on all the main access roads into the Crimean Peninsula. At around 4:30 in the morning, Russian special forces stormed the building of the Supreme Council of Crimea and the Council of Ministers. The Russian flag was raised above the Parliament building, and heavily armed Russian soldiers were stationed around the perimeter. Russian snipers took up positions on the roof of the Parliament building. There is a video in the evidence that has been submitted to the court which shows these events, and we would ask you to view it if you haven't already done so, because it will leave you in not the slightest doubt that this was a professional military operation against the institutions of democratic self-government in Crimea, a military coup, in other words. The CSDF paramilitaries then set about rounding up the members of the Supreme Council from their homes, and they brought them at gunpoint to the Parliament building. Shortly after 10 o'clock in the morning, the Parliament building was disconnected from all forms of external communication with the outside world. So once the members of the security of the Supreme Council were assembled, under duress from armed Russian military personnel, without the requisite quorum and cut off from the outside world, the Supreme Council then adopted a resolution immediately dismissing all members of the Council of Ministers and appointing Sergei Aksyonov as Chief Minister and head of the regional government. Aksyonov had been the leader of the Kremlin-backed Russian Unity Party, which had polled at 4% in elections the year before. Democratic government in Crimea was quite literally broken over the barrel of a gun. As the day progressed, 500 further Russian troops arrived in Crimean ports by boat, and 4,500 personnel that day arrived in Crimea via military aircraft. By nightfall on the 27th of February, the legitimate civilian government had been forcibly removed and replaced with a puppet regime installed by the Russian government. Russian troops had successfully prevented the Ukrainian military from leaving their barracks during the day and had begun an operation to disarm them. Reinforcements from mainland Ukraine had been unable to enter Crimea because the Russian forces and CSDF were in unassailable military control of all major routes into and out of the peninsula, so that in just one day Russia had occupied Crimea militarily and assumed effective overall control over the territory. It had successfully installed a subordinate local administration that was entirely dependent upon Moscow for its military, economic and political survival, and directly and through this subordinate administration, Russia was undeniably in a position to wield decisive influence and de facto control over the territory from the end of the 27th of February at the very latest. Over the following month, Russia consolidated its control of Crimea, with additional troop deployments arriving on the peninsula through every available port of entry at regular intervals. The Russian FSB supplied AK-47 assault weapons and ammunition to the CSDF and operated in close coordination with them all the way throughout the operation, blockading Ukrainian military positions, joint operations being carried out, with Ukrainian forces being confined to barracks by force, encircled and then subdued by overwhelming superior military force. It is clear beyond argument that Russia was exercising extraterritorial jurisdiction in the Alskiny sense on the territory of the Crimean Peninsula from the 27th of February onwards. Article 1 of the Convention applied to Russia's actions during that period on the basis of its effective control of the territory outside its national boundaries. That's our answer to the Court's first question. Russia is answerable to this Court for violations that were committed by its own forces and for those committed by its local subordinates from the day of the coup onwards. It's answerable not only for the acts of physical violence which occurred in the weeks immediately following the coup, but also for the campaign of political repression that was subsequently implemented by its puppet regime in Crimea. Immediately after the coup, the new leadership set about forcing through a raft of measures designed to give the Russian occupation a spurious veneer of legality. The aim was to provide pretextual legal justification for the planned annexation, which had been the intention all along. Russia's new puppet regime in Crimea announced its intention to hold a referendum, one which was both unconstitutional, unlawful and undemocratic. The so-called referendum was held on the 19th of March and was in flagrant violation of the relevant international standards. It was marred by intimidation and vote rigging. The options on the ballot paper didn't even include maintenance of the status quo of Crimea as part of the sovereign territory of Ukraine. There were numerous irregularities in the process, and there was no effective screening of voter registration. Armed paramilitaries were stationed at the polling booths, and opponents of the annexation were declared persona non grata. National minorities and groups opposed to annexation, not surprisingly, boycotted the referendum, partly through fear and partly because they rightly understood it was illegal. Other groups were effectively disenfranchised by force. Recognising the illegitimacy of the whole process, the OSCE declined to provide international observers, and the referendum was subsequently condemned by the Venice Commission here in Strasbourg on the basis that it had been both unlawful and incompatible with the applicable European standards of democracy. The referendum was subsequently declared unconstitutional and void by the competent domestic courts of Ukraine, which, according to Mr. Swainston's argument, continued to have jurisdiction at this time. The de facto authorities of Russia's puppet regime nevertheless announced a 97% majority in favour of annexation to Russia. on a turnout of 83%, figures that were almost immediately dismissed by all relevant international organisations as utterly implausible. The United Nations General Assembly, and this is where we get to an unquestionable position, the United Nations General Assembly adopted a formal resolution declaring the referendum invalid and confirming the position of the United Nations as a whole that the referendum could not form the basis of any alteration in the legal status of Crimea as a constituent part of the sovereign territory of Ukraine. Resolutions to exactly the same effect, i.e. that the referendum is null and void and cannot alter the status of Crimea as a part of the sovereign territory of Ukraine, were adopted by the European Union, the Committee of Ministers of this institution, the Council of Europe, and the Parliamentary Assembly. None of this, however, stopped the process of unlawful annexation. The day after the referendum, the Supreme Council of Crimea, now fully under Russia's control, proclaimed Crimea's independence from Ukraine. It then issued a proclamation purporting to terminate the authority of the Ukrainian state in Crimea and unlawfully transferring all its property, powers and facilities to the so-called Republic of Crimea. This even extended to the physical property belonging to Ukrainian trade unions and other public organisations. On the 18th of March, the day I think Mr Swainson has finally settled on, the representatives of the subordinate administration and the Russian Federation sat down together and co-signed a piece of paper which they called a Treaty of Union. A Treaty of Union. This pretended international agreement purported to designate all residents of Crimea as Russian citizens. It purported to absorb the Crimean institutions of government into the status apparatus of the Russian Federation, and it purported to apply Russian legislation throughout the territory of Crimea. The bogus international treaty was subsequently ratified by only one state, the Russian State Duma, on the 20th of March 2014. So, Mr President, it's on the basis of those self-serving instruments that Russia now argues that Crimea has been legally absorbed into the sovereign territory of the Russian Federation from, I think, the 18th of March, relying, we say, on this transparent legal fiction. Russia now comes before this court today and asserts its jurisdiction over Crimea on the basis of territorial sovereignty. Ukraine invites this court to hold that these pseudo-legal instruments should be given no legal recognition whatsoever by this tribunal. The military coup, the undemocratic referendum, the bogus treaty, and the unlawful annexation have all been roundly condemned as illegal by the international community and as having no effect on the status of Crimea as part of Ukraine. Speaking with one voice, the United Nations General Assembly, the European Union's Council, and the Council of Europe itself have all refused to recognise Russia's occupation and annexation of Crimea. Each of these institutions has condemned Russia's acts as acts of aggression against a neighbouring state and unequivocally reaffirmed the sovereignty and territorial integrity of Ukraine in respect of Crimea. The Parliamentary Assembly of the Council of Europe suspended Russia's voting rights for 5 years, and the EU Council imposed targeted sanctions on Russian officials in connection with actions relating to Crimea aimed at undermining the territorial integrity and sovereignty of Ukraine. So that is the position as a matter of international law, yet Russia asks this court to rule. That's effectively what's happening here. They are asking you to stand out from the entire international community and to rule that they are the territorial sovereign over a territory in which they are currently in unlawful occupation. A proposition which has been unequivocally and unanimously rejected by the entire international community and its representative organisations, who have been steadfast in their refusal to accord any form of legitimacy or recognition to the bellicose actions of the Russian Federation. Mr. President, at the risk of stating the obvious, accepting Russia's claim, as it has been advanced to you this morning, would undermine an absolutely, probably the absolutely critical cornerstone of public international law, the prohibition on the use of force by one nation on the sovereign territory of another without that nation's consent, without a resolution of the UN Security Council, and in the absence of any possible claim to self-defence. Russia's argument here is a direct and frontal attack on one of the most basic precepts of public international law, the prohibition on the use of force. And it is Russia who has put this in issue, because it is Russia who is asserting territorial sovereignty after a date it can't quite decide upon between the 18th and 21st of March, all based upon a completely bogus set of legal instruments that this court cannot, in conscience, give the slightest recognition to. Russia's stance also involves a veiled attack on the institutional integrity of the Council of Europe itself. Both the Parliamentary Assembly and the Committee of Ministers, as I've said, have condemned Russia's actions, and they've refused to accord them any legal recognition whatsoever or any legal validity whatsoever. But Russia is today asking the judicial branch of the Council of Europe to reach the opposite conclusion to that which has been forcefully reached by the parliamentary and executive branches of the same organisation, and to legitimise its decision to take part of Ukraine's sovereign territory by force. Like the international community of which this court forms an integral part, Russia's submission should be roundly rejected by the court. Since Ukraine remains the sovereign state for the purposes of international law, it follows that Russia's Article 1 jurisdiction is and has been territorial in character from the beginning until today, and is premised from the beginning, from the coup until today, upon its continuing effective control of territory outside its national boundaries, directly and through its wholly subordinate local administration. Mr. President, members of the Court, I turn now to the question of the existence of a prima facie evidence of an administrative practice. The evidence that Ukraine relies on to establish the existence of the administrative practice we allege comes from two sources. First, we invite the Court's attention to a series of reports from unassailable international sources using reliable and robust methodology, confirming the very pattern of human rights violations we alleged, directed against a target group which have in common their opposition to the illegal occupation. I've already mentioned the two reports by the United Nations High Commissioner for Human Rights, together covering the period from the date of the military coup up to September last year, September 2008. The first report in 2007 takes you from 2014 to 2017. The second report, of September of last year, brings the position up to date. And they are based, as I said, on regular monthly reporting combined by the UN Human Rights Monitoring Mission in Ukraine, which began work 2 weeks after the coup. I'll deal in response, in my reply to in our submission, outrageous suggestion that the United Nations methodology is somehow about reflanneling a lot of vague analyses by NGOs. That is an extraordinary thing to say about the competent organ of the United Nations, whose monitoring function has been established with the authority of the Human Rights Council, using an established methodology of interviewing those who have managed to get out of Crimea. The reason why the OHCHR has not been allowed into Crimea is because the Russian Federation has blocked entry. That's the same reason why our investigation team has had such difficulty gaining access to the territory of Crimea, because those who are responsible are blocking entry to prevent it from being fully investigated, which is exactly why an interstate court which can force and make directions for the examination of evidence is so vital, because Russia has managed thus far to hide, shroud and obstruct international scrutiny in detail, but the OHCHR and others have managed to gain information from those who've got out of Crimea. And that's the normal standard methodology used in any situation of unlawful occupation where there is a military reason obstructing the effective investigation of human rights situations on the ground. The OHCHR reports state in terms that they've only recorded allegations that could be verified and corroborated, and they paint, we say, a dystopian picture of the Russian government's authoritarian grip over the population of Crimea. They record a full range of human rights violations occurring more or less consistently over the reporting period, and targeted against all those who oppose or even are perceived to oppose Russia's unlawful occupation. They are a direct and forthright condemnation of an administrative practice of human rights violations. They could not be clearer. The most recent report records human rights violations committed against 167 separate victims in the space of a year. According to the United Nations, the victims and the violations included torture involving the use of electrocution and sexual violence by state agents on people in custody. The High Commissioner also reported systemic problems of accountability and a lack of impartiality in the administration of justice, which was said to be ongoing as recently as last September. That's September 2018, just to bring the position up to date for the Court's consideration. A very similar picture emerges from the 2014 report of the Council of Europe's own Human Rights Commissioner and a 2014 report from Human Rights Watch, no doubt one of those criticised for being stooges of George Soros, I suppose. But Human Rights Watch, as the Court will know, is an extraordinarily reliable human rights monitoring organisation whose reports have been taken into consideration and relied upon by the United Nations itself in terms of viewing human rights violations in situations of armed conflict. And for the Russian Federation to use this as yet another disgraceful attempt to smirch the name of George Soros with all the connotations that that has tells you the depths that they are prepared to take this court to. In order to try to obstruct a proper investigation of the way they conducted themselves. It's not just the international organisations that we need to be concerned about. The pattern of allegations is also consistent with the finding of Russia's own ombudsperson. In her annual report for 2014, she recorded 37 cases of enforced disappearances, all of them either Crimean Tatars or ethnic Ukrainians. That's Russia. I mean, almost certainly a massive underreporting, but that's Russia's own ombudsperson's report. These reports and others like them led the Parliamentary Assembly of the Council of Europe to conclude in 2016 that Crimea was operating under, quote, a climate of severe intimidation, unquote, arising from a consistent pattern of human rights violations and an absence of effective accountability mechanisms. Taken together, these objective international analyses comprise the first source of evidence of an overall administrative practice. The other source is the collection of witness statements appended to Ukraine's written submissions, which provide credible primary evidence of examples only of human rights violations clearly attributable to the Russian Federation. Of course, they are samples only, and for Mr. Swainston to complain that there aren't enough examples when Russia itself has blocked all possible investigations on the ground, it is outrageous. I want to highlight one or two specifics from the statements that we are able to put forward as illustrations of the administrative practice. The first group, or the first of the specifics, concerns the ill treatment of both military and civilian personnel in two principal detention facilities, so these are detention cases, in the weeks immediately following the coup. The first facility, a Russian military facility, attributable directly to the Russian government, is the Russian military prison in Sevastopol. The evidence you have describes the detention of 3 Ukrainian colonels at that facility and several civilian activists and journalists, all of whom were reportedly subjected to various forms of torture and ill treatment by their Russian captors. But even more barbaric acts of torture were inflicted on the detainees held by the CSDF paramilitaries at the military commissariat in Simferopol. One of those detained in that building was a man called Andriy Shikukin. He had been a prominent activist in the Euromaidan movement. Mr. Shikukin was initially arrested by CSDF paramilitaries, blindfolded with duct tape, and taken to the military commissariat, where he was then unlawfully detained for 11 days before being released under the authority of the Russian Foreign Ministry. Just to be clear, it was the Russian Foreign Ministry who authorised his release. Whilst he was detained, Mr. Shikukin describes how he was cut repeatedly with a knife, electrocuted, subjected to mock execution, and forced to sit naked for many hours on a chair with his hands and feet tied so that he was restrained naked for hours on end in between bouts of active torture. He also, as do others, described the torture of other detainees at that facility. One of the other people who was detained at that facility has also been mentioned briefly by Mr. Swainston, a man called Reshat Armetov. Very much the same modus operandi. He was a Crimean Tatar activist who appears to have been initially detained by the CSDF at a pro-Ukrainian demonstration in Simferopol, and after Akhmetov had been taken to the military commissariat, he just disappeared. And his body is discovered 5 days later, showing signs of torture all over the body. His head, like Mr. Shikukin, his head was bound with duct tape and his legs were tied together. Now, it's right to say that that facility was staffed by CSDF paramilitaries, but the perimeter was guarded by Russian soldiers, and as I said a moment ago, Russia was plainly in immediate de facto control because it was the Russian Ministry of Defence that conducted negotiations with Ukraine for the release of the people who survived this campaign of torture in these facilities. So it is clear beyond doubt that the Russian Federation is answerable for these crimes. The primary evidence also records many instances of enforced disappearance and a number of other confirmed cases of homicide. It provides first-hand evidence concerning the unlawful appropriation of property, the unlawful seizure of private enterprises, the revocation of banking licences and the confiscation of customers' assets, and the adverse effects of compulsory passportisation, the harassment of ethnic Ukrainians and those loyal to the Ukrainian state, the persecution of religious leaders and the persistent intimidation and harassment of the Tatar community. Viewing the witness testimony against the backdrop of the consistent international United Nations reports, the Commissioner for Human Rights reports of the Council of Europe, and all of the NGO reports which are consistent, the overall picture is absolutely clear. Russia stands credibly accused of an accumulation of related convention violations, violations which share a common political purpose, a common political motivation, that is the suppression of political opposition to the unlawful occupation, and violations which are sufficiently numerous and interconnected, very obviously, to amount to a pattern or system. We say the pattern of persecution plainly meets the Court's definition of an administrative practice. Russia also stands credibly accused of official tolerance in relation to these targeted human rights violations. That, of course, is the second element of an administrative practice identified in this Court's case law. The evidence as a whole demonstrates that in the face of numerous reports from unimpeachable international sources confirming this pattern of persecutory human rights violations, the relevant Russian authorities have failed to take any action either to prevent the continuing commission of violations or to punish the perpetrators. They failed even to investigate the alleged violations in a manner that conforms to the requirements of the Convention. Overall, it's resulted in a culture of impunity that goes well beyond the Court's threshold of official indifference and bears the hallmarks of tacit state policy. What other explanation could there be for the decision of the Russian Federation and their subordinate authorities to grant a blanket immunity to the CSDF paramilitaries? These were the forces who had been responsible for the most brutal human rights violations in the immediate aftermath of the coup. And they were also prime movers in the continuing pattern of harassment and violence towards perceived Ukrainian loyalists. They were the sharp end. But despite repeated calls from international organisations and monitors for these units to be disbanded and held accountable for their crimes, the Russian authorities granted them an official immunity for the crimes that they had committed and formalised their position in the new administrative structures. Russia has offered absolutely no explanation for this general amnesty. In the absence of a plausible justification for this shocking policy decision, the obvious inference is that Russian authorities were not willing to hold the perpetrators accountable for crimes that they had committed in the service of the motherland. Wouldn't be the first time. This also sends an unmistakable message to those in Crimea who might otherwise be contemplating political opposition. The chilling message is that resistance to the occupation is not only futile, but also extremely dangerous, because the rule of law applies selectively. Those who support the Russian regime are free to commit criminal acts against those who oppose it, safe in the knowledge that their crimes will almost certainly go unpunished. And there's abundant evidence before the court establishing that Russia has willfully persisted in neglecting its obligations to bring the perpetrators of these crimes to account, and there has been a chorus of complaints about the deficit of accountability from all competent international institutions. That was the clear conclusion reached by the High Commissioner for Human Rights in his 2017 report. I'll just read you one paragraph. The Russian authorities in Crimea have failed to investigate most allegations of human rights violations committed by the security forces or armed groups acting under the direction and control of the state. Failure to prosecute these acts and ensure accountability has denied victims a proper remedy and strengthened impunity, potentially encouraging the continued perpetration of human rights violations. That is the assessment of the competent highest authority of the United Nations. The High Commissioner's concerns about that culture of impunity have been a consistent refrain from the international human rights monitors. As I say, the same point was made by the Council of Europe Commissioner and Human Rights Watch. It's also reflected in this passage from the 2016 resolution of the Parliamentary Assembly of this institution. And I'm quoting again. As far as the people of Crimea are concerned, fear of retribution affects the independence of the courts and, in particular, the willingness of the police and prosecution services to hold to account perpetrators of crimes against perceived or actual Ukrainian loyalists. The lack of accountability isn't just a violation of the procedural obligations inherent in many of our convention rights. It's part of the administrative practice itself. It's one of the means by which Russia suppresses all dissent in its unlawful occupation of Ukrainian territory. It's an essential component of the administrative practice. It is, to some extent, the administrative practice. The plain fact is that Crimea has become an accountability wasteland for those who are seeking accountability for crimes committed against perceived opponents of the occupation. And it's not an accidental accountability wasteland, it's an accountability wasteland because that is evidence of the tacit policy of the Russian Federation. Which brings me, towards the end of my submissions, to the question of domestic remedies. I can deal with this, as you probably imagine, relatively shortly. Ukraine invokes the fundamental principle that the non-exhaustion rule has no application in cases concerning the existence of administrative practice. Where there is a prima facie case of pattern or system, and there could scarcely be a stronger one, even in principle, than this, where there is prima facie evidence of a pattern or system, coupled with official tolerance, the applicant state is not required to establish that there have been either individual or collective attempts to exhaust domestic remedies. The existence of a common political purpose behind the violations that have been referred to in the evidence in these proceedings is one of the defining features of an administrative practice, a common political purpose. That's the linkage. And the principal objective of Ukraine's applications is to vindicate the rights of those who have been the victim of this pattern and to put a stop to the pattern of violations and prevent their recurrence. Ukraine is not, may I make it clear, asking the court to reach individual decisions on each separate application, each separate violation, or to award just satisfaction to each of the individual victims. Instead, as is entirely appropriate for the reasons that the Deputy Minister explained at the outset, Ukraine is asking this court, since it's the only remedy potentially by which the international legal community can do anything about the situation, to take account of the whole pattern of violations disclosed on the totality of the evidence and to find that the Russian Federation is responsible for an administrative practice committed in order to consolidate its stranglehold over the population and territory of Crimea. As the court held in the Georgia and Russia admissibility decision, the rule requiring exhaustion of domestic remedies doesn't apply where the applicant state complains of a practice as such with the aim of preventing its continuation or recurrence, but doesn't ask the court to give a decision on each of the cases put forward as proof or illustrations of that practice. That description precisely corresponds to Ukraine's position in the present interstate case. Putting the same point in a slightly different way, Ukraine submits that such remedies as are shown to exist in principle are purely theoretical and illusory in the context of violations committed by Russian state agents in Crimea against perceived opponents of the illegal occupation. That is an alternative response and an alternative reason for rejecting Russia's arguments on non-exhaustion, but it's based on the same evidence. Those who have been the victims of violations are not obliged to make use of theoretical remedies that provide no realistic likelihood of success, particularly when there are credible reasons for doubting the independence and impartiality of the domestic courts. The findings of the OHCHR, the UN, the Council of Europe Commissioner for Human Rights, the Parliamentary Assembly of the Council of Europe, and of Human Rights Watch all equally underline the futility of seeking to make use of domestic judicial or administrative remedies in the Russian Federation for the category of violations that are in issue in this case. Indeed, the absence of rule of law is at the heart of the complaint. Finally, Mr. President, and very briefly, I am going to turn to the Court's additional question that was added at a late stage concerning Ukraine's the timing and scope of Ukraine's application and the relevance of the 6-month time limit. The question was added in July and refers to 2 previous decisions of the Court. At first glance, it seems to raise a complex interplay between different strands of the Court's jurisprudence. But in our submission on a closer examination, the answer to the question is very simple indeed and involves a straightforward application of the Court's usual practice on the application of the 6-month time limit. So if I can just recapitulate, the general rule expounded by the Court in the Radomilja case against Croatia is that the scope of a case before the Court is circumscribed by the facts as set out in the originating application. The Court is not limited by the legal qualification given to those facts by the applicant. It can examine the facts against any provision of the Convention, and not merely the provisions that the applicant has invoked, but in a case where the violation is finite in time and does not amount to an ongoing situation, the Court is limited to the facts that were pleaded by the applicant at the time the application was first introduced. That's the effect of the Radomilja decision. The applicant can clarify or elaborate on the facts in the original application, but that flexibility will not extend to allowing an applicant to introduce a wholly new complaint after the 6-month time limit has expired. Now, that decision is an individual rather than an interstate case, but the way in which the point is expressed is capable of covering both in principle. But that is not to say that it applies equally in both situations, because the proposition in Radomilja is clear enough when it's applied to a finite set of facts or to a situation that has definitively come to an end. In relation to a violation that has a fixed date or a fixed end...
I kindly ask you to conclude.
I'm sorry?
I kindly ask you to conclude.
Yes, I'm in the process of concluding, exactly. In relation to an application with a fixed end date, then it's possible to calculate a 6-month time limit. But the principle in Radomilja, we say, can't apply to an interstate complaint involving an ongoing administrative practice. It's no more... That submission is no more than the straightforward application of the well-settled principle in the Court's case law that the 6-month time limit has no application to ongoing situations alleged to violate the Convention. So, whereas the situation is ongoing, the time limit does not apply, and that must, as we submit, be the same for an administrative practice as it is for an ongoing violation. Mr. President, members of the Court, those are our submissions.
I thank you for your submissions. I now invite the judges of the Grand Chamber wishing to do so to put their questions to the parties. Judge Paschal.
Thank you, Mr. President. I have questions to both parties. Let me start with my personal experience. Prior to coming to this court, I worked as advocate for more than 35 years, and during that time I was also very often an informal mediator. I know to what extent it may be very difficult to explain to clients that an unpleasant compromise could be better than ostensibly a winning judgment. You are the representatives of two states that are in a deep conflict. You have a responsibility not only with regard to all citizens of these two states, but also with regard to citizens to all states of Europe, because this conflict touches them. We know from the history of humankind that every conflict between two states must finish with a compromise in the end. And now let me put you the concrete questions. Are you willing to offer a compromise to the other party in order to reach a friendly settlement? If you are willing to do so, could you describe the content of such compromise? If you are not willing to do so, could you explain to the court the reasons why you are not willing to offer the compromise to the other party? Thank you for your answers.
Thank you. Judge Kulbro.
Thank you, Mr. President. I do have three brief questions. They are of a legal nature rather than a factual nature, and as such, they are directed to both parties. The first question concerns the legal question of attribution. Assuming that the court would reach the conclusion that the alleged victims fall within the jurisdiction of Russia, it would also have to assess whether the alleged violations can be attributed to Russia. And there, unless I'm mistaken, it seems to me that the views of the two governments, the applicant and the defendant government, seem to differ slightly. Ukraine is arguing that Russia is responsible not only for its own forces, but also for the local forces of the administration, while Russia, on the other hand, is saying that it is responsible if it is directly involved or if it has directed or instructed the local authorities. And my question is quite simple but significant nevertheless. Are the parties inviting the court to confirm its long-standing case law concerning attribution, or are the parties inviting the court, in light of ICJ jurisprudence, to somewhat deviate from or modify our case law on this issue? My second question concerns the legal basis for Russia's jurisdiction over Crimea after 18 March 2014. The parties are in agreement that Russia does exercise jurisdiction after 18 March, but seems to do so on two fundamentally different approaches. According to Ukraine, it is effective control over an area outside its territory, extraterritorial jurisdiction, while Russia, and now I'm quoting from the observations on the admissibility there, the Russian government said it is OTOs to inquire whether the nature of Russia's jurisdiction from 18 March 2014 and onwards was territorial or effective control. On the contrary, such an inquiry would encroach upon political issues of sovereignty between states which are outside the court's jurisdiction. However, if I was not mistaken, in the oral intervention, the Russian government was saying that it exercised territorial jurisdiction. And therefore my question is, are the parties inviting the court to assess whether the jurisdiction is territorial or extraterritorial, and in the affirmative, will it have a bearing on the assessment of the specific complaints raised? My third and last question, that is the sensitive question of lawfulness under public international law. The parties are in dispute about many events, in particular whether they are lawful under public international law. I will only turn to one of them, and that is the present legal status of Crimea in relation to, respectively, Russia and to Ukraine. And the question is, can and should the court have a view on the legal status of Crimea in relation to the two countries? And should the court in that context also have regard to what is the view of the international community? Russia seems to say quite clearly that this is outside the court's jurisdiction, while Ukraine seems to be more ambiguous. In the pleadings it is said that it will be for the court to decide if necessary. So my question is it necessary for the court to address this issue, and will it have a bearing on the subsequent assessment of the specific complaints raised? Thank you.
Thank you. Judge Nussberger.
Thank you very much, President. I have three questions, and the first question falls into two questions. The first question concerns the burden of proof, and both parties have quoted repetitively the UN Human Rights Commissioner's report. And there in paragraph 2, it said, I read out, Human Rights Monitoring Mission in Ukraine has not been provided access to Crimea by Russian Federation authorities since its former head of mission, accompanied by former Assistant Secretary General for Human Rights Ivan Simonovich, on 21st and 22nd March 2014, so the date when Russia ratified the so-called accession treaty. So my first question in this context, this is the date. Has there been any other independent international monitoring mission allowed after this date, which could move around freely in the territory of Crimea? And in this context, I would be interested on the assessment of the burden of proof. You know that the court would always start out from the principle affirmanti incubit probatio, so the burden of proof lies on the person making an allegation. But you also know that we have lowered this standard, for example, in the cases El-Masri, Hassan, or Al-Nashiri. I quote, if the events in issue lie wholly or in large part within the exclusive knowledge of the authorities of the respondent state. So now I understood during the oral submissions the respondent state, the government agent of the Russian Federation, that he said that the burden of proof cannot be shifted. It can only be shifted in individual cases, but not in interstate cases. And my question is, on what argument or do you base this assumption that the burden of proof cannot be shifted in an interstate case like this one? The second question is on the date. I'm a bit confused. I see now in the oral hearings it was always said that it's, both parties agree that after 18th of March 2014, Russia had jurisdiction, but I also found in the submissions the date of the 21st of March, so I understand that was when the Russian Duma had ratified the treaty. But so my question is, I understand that you mean, you have in mind the 18th of March, but so on the 16th of March there was the referendum, on the 17th of March there was the Declaration of Independence. So my question is, do you assert that on the 16th and 17th of March, Ukraine still had full effective control in Crimea? And the third question is to the Ukrainian government. Russia argued in its observations on 29th of December 2018 and repeated it orally that at the relevant time there were 20,315 service Ukrainian servicemen in Crimea. And I understand that it's about the same number of servicemen from Russia in Ukraine. I would like you to elaborate on the assessment of effective control in a situation when both parties have military personnel of about an equal number in a certain territory. Thank you.
Thank you. Judge Tuz-Muhamedov.
Thank you, Mr. President. I have identical questions for both parties, and I should probably pick up from where my learned colleague, Judge Nussberger, just finished. So we've heard the number of 25,000 of authorized personnel. What were the legal, political, military, maybe other considerations that prompted the parties to include that ceiling on the number of Russian personnel assigned to the Black Sea Fleet of the Russian Federation on the territory of Ukraine into the 1997 agreement? Further, what is the parties' understanding of paragraph 2, article 4 of their agreement on the status and conditions of presence of the Black Sea Fleet on the territory of the Ukraine, and what was the practice of its application? And for the benefit of the court and the parties and the gallery, I should cite that provision. The Russian party shall annually and before 1st January inform the Ukrainian party in accordance with a list coordinated by parties of the total number of personnel and main armaments of the Black Sea Fleet of the Russian Federation on the territory of Ukraine, end of quote. What were the maximum numbers, again, proceeding from the question that was asked a moment ago by Judge Nussberger, what were the maximum numbers of service personnel of parties concurrently deployed by them in Crimea from 27 February to 18 March? And on a separate issue, have the parties exhausted all means, modes, and sources of gathering evidence for the current proceedings? Is it complete in its amount and scope? And if it is not, what are the parties' remaining requirements in order to make it complete? Thank you.
Thank you. The court will now withdraw for 20 minutes, following which the parties will be able to submit brief observations in reply to each other's submissions and reply to questions from the judges. The hearing is suspended.
La Cour
Please be seated. The hearing is resumed. I call Mr. Galperin.
Mr. President, honourable judges, I've taken instructions, including from Mr. Galperin, and I will be answering the questions put by the court. I will try in the process to pick up some points made by my learned friend at points where that's relevant. Dealing first with the question from Judge Petschel on the readiness of the parties for compromise. In terms of this case, it is difficult to compromise this application. When the application is pressed, we have to respond to this application. But as I say, I've taken clear instructions, and the position of the Russian Federation is that it appreciates what seems to be an improvement in relations between the two countries. I'm sure we've all noticed a recent prisoner exchange, which offers promise. And I'm also instructed that we would hope that this general improvement in relations could extend broader, including in relation to the present issues. But that's as far as I can take it for now. The second question came from Judge Colbrough and dealt with attribution, and I was asked whether our position is changing in the sense of requiring or requesting the court to move away from its established position on attribution. Well, the court will be aware that the Russian Federation has long taken the position that the court's approach on attribution is different from the approach under public international law and authority of the International Court of Justice, including in particular the Nicaragua case. Having said that, the court has, in its own jurisprudence, sought to distinguish the ICJ cases on the Ilascu line of reasoning in particular. And no doubt this is why Ukraine tries to rely on Ilascu, because the suggestion seems to be that if an outside state supports a subordinate administration, two things follow. One is effective control, and the other is attribution, in the sense that there seems to be some kind of strict liability imposed on the supporting state. We say that is a wrong approach in public international law, and there should be no doubt about our primary position on that. But we also say that there is no basis for applying Ilascu here, for the reasons given by Mr. Galperin. And if I can just emphasize that, to apply Ilascu, the supporting state needs to be keeping out a legitimate government which is seeking to restore the rule of law and democratic values. If you still have your speaking references with pictures in, page 1 and page 2 are pictures of the trade union building in Odessa. That was protection of democratic values in Odessa when people objected to the coup in Kiev, and we shouldn't be confused about where the coup occurred. There was one, and it was there. And if we talk about what democratic values were being projected, we should also look at pages 3 and 4. They show the emblems of the Azov battalion, and the new government in Kiev created that to accommodate the right-wing extremists who helped, in the course of violence in Kiev, to bring it to power. Now, we all recognize those symbols. It's not the first time that we've seen them. Indeed, they are probably the primary reason for this court's very existence. And these are the democratic values that were being projected against the east of Ukraine and potentially against Crimea. And if you just pick up the next page, page 5 in the handout, the coup in Kiev happened on the 21st of February. President Yanukovych's government was gone. Here we've got a Western reporter on the 22nd of February, immediately afterwards, reporting the reaction of a huge number of people in Crimea, the Russian-speaking majority, who, as he says, were immediately protesting, demanding reunification with Russia, because they were anxious, because they saw what was coming. And nobody can say that that anxiety was not justified. Any doubt is resolved by those pictures of Odessa. Now, the next question was on the basis of the court's jurisdiction, whether effective control or territorial. Now, I began by emphasizing that my learned friend's submissions were political. If I could have called witnesses to prove that Ukraine's case is a political case with human rights window dressing, I couldn't have done better than call the representative for Ukraine and my learned friend, Mr. Emerson. I stopped counting references to the referendum when, with their submissions, we got up to around 64. But it became absolutely clear that this is a political case when they indicated that they wanted some finding on the legal status of Crimea. Let me be pellucidly clear. This court has no jurisdiction to make any decision on the status of Crimea. It is a political issue raised by Ukraine. It is no part of this court's business, and it is irrelevant because the Russian Federation accepts that the convention applied from the 18th of March. And just to clear up the date issue, that is the date of the Treaty of Accession of Crimea, which was applied provisionally from that date, and it was ratified by the Duma on the 21st. But Russia accepts jurisdiction in Crimea, and the court has jurisdiction from the 18th of March. Before that date, including on the 16th and 17th, Russia did not have jurisdiction, as has been alleged, on the basis of effective control. That, including the process of the referendum, was a period during which the people of Crimea were finding their own way and taking their own way against the background of the collapse of constitutional government in Ukraine as a whole. But again, this question of the rights or wrongs of the referendum is nothing to do with this case, totally irrelevant. The next question, I think, was Judge Neuberger on the issue of monitoring missions and what access they have had. I can't now tell you what the details are in relation to all monitoring missions. But in order to try to be helpful, I can point out that the Office of the High Commissioner for Human Rights addressed this in a report for the period 13th of September 2017 to the 30th of June 2018 at paragraph 17. And what we see there is that the Commissioner was not prepared to accept for his staff conditions that were put down for the mission to attend. And my understanding is that the conditions included things like visas. Now, this is, on any view, a tense part of the world at an extremely tense time. One might have hoped that questions of visits by monitors would not be politicised to the extent of people objecting to taking visas to visit in order to do proper monitoring. Whatever the rights or wrongs of that, it doesn't improve the quality of the evidence, because it's not evidence when you get a commentating report that doesn't give sources, that doesn't give detail. And my learned friend has referred to this report. It says things like the legal system applied in Crimea often failed to uphold fair trial rights and due process guarantees. An interesting American phrase, but there we are. No source is given, no footnote, no detail. And when you look at the actual cases that are relied upon by Ukraine in detail, you do see the courts dealing appropriately with cases. Similarly, paragraph 13, without source, said the Russian Federation authorities in Crimea have failed to effectively investigate most allegations of human rights violations by the security forces, etc. This was a paragraph that my learned friend quoted. But again, when we looked at the Akhmetov case on the specifics of evidence before this court, there was an investigation which has been obstructed by Ukraine. And interestingly on that, the Human Rights Commissioner's report picks up specifically the case of Mr. Akhmetov at paragraph 81, and it complains that the investigation has proceeded intermittently. It makes no mention of the fact that during the period of this report, Ukraine was refusing to assist. So if in this report there had been a proper effort to get into the detail of cases, that would surely have been a material thing to mention. So that feeds into this question of whether the burden of proof should shift. And in my submission, the representative for the Russian Federation was absolutely right to say that the burden rests on Ukraine and it should not shift. Remember that my learned friend Mr. Emerson defended the Human Rights Commissioner's report on the basis, it was said, that the Human Rights Commissioner had interviewed lots of people from Crimea who had moved to Ukraine. Well, there aren't many footnotes to evidence that, but if it's right, and if it's right that lots of people have moved to Ukraine because of this alleged oppression, why do we not have witness statements from them, from Ukraine? Why is it failing to deploy primary evidence in this court? The only sensible inference at this point is that it doesn't have the witnesses to produce those witness statements that would show a proper administrative practice. And this picks up the last question that was asked about what the approach to evidence should be. Well, with respect, there shouldn't be a further one by this court in this application, because this is all about admissibility. And Ukraine has had years to come up with proper primary evidence, and they've failed to do so. And that should be an end of it. I suppose one could say that if the case proceeded further to a merits phase, then we might have to have evidential commissions, we may have to have visits, we may have to have attempts now to get to the bottom of what happened in these individual cases. But I emphasize the problems with that. It's years after the event. Who knows the witnesses that Ukraine will furnish, how is it possible to test absolutely that they were there, that what happened is alleged to have happened, what did actually happen? It's years after the event. This court is not a court that's designed for primary evidence gathering, and that brings us back to the admissibility criteria, because those do require fact-finding by a domestic tribunal within a reasonable time of the alleged violation. There are statements, secondary statements, that the Russian courts in Crimea have not provided proper investigation. But on the facts of the only individual cases that you're able to look at, that is contradicted. We've seen in a number of instances, the most serious instances, Ukraine misrepresenting what has happened or misrepresenting the position on investigations, particularly where it's obstructing those investigations itself. There are a couple of points that I would, with the President's leave, cover before I finish. One is the Radomilja case. My learned friends seem to try to suggest that that doesn't apply when one's dealing with administrative practice. Well, it jolly well does. It's clear from the decision that the 6-month rule applies to any additional allegations that are made, and that must include any additional allegations made in the course of a case that's alleging administrative conduct and administrative practice. And that point rather goes together with our objection that Ukraine's submission in December 2018 sought to extend the period of its complaints by 2 years, which I only have this opportunity now to respond to. Plainly not enough. The point is, when you have these broad complaints based on secondary sources, without footnotes, general allegations that Russian courts failed to investigate or whatever, how is Russia supposed to check that? How is the court supposed to check that? There's no identified victim, there's no identified case, there are no specifics of dates or courts or anything. That cannot be evidence, because it's not a sensible proposition that could be tested in any court of law, let alone a review court like this one. So we do, with respect, object to the ignoring not only of domestic remedies but the 6-month limit. And finally, I've been provided with some statistics. Reference was made to the Russian Commissioner for Human Rights, and I've got some statistics which are interesting. They come from the Ministry of Internal Affairs in, I think, May 2015, the 7th of May 2015. And as at that time, there were 800 cases of missing persons in Crimea. These are people who are being looked for a whole variety of legal reasons. 75 of those seem to have overt aspects of criminality that could be involved in the disappearance. But overall, amongst people missing, and particular groups that are, I think, currently being investigated, there were 13 Tatars, 24 Ukrainians, and 119 Russians. Now, that broadly reflects the demographic in Crimea, and I'm told that it's not higher than other Russian regions. So, overall, we would say that there's nothing to justify my learned friend's claims of outrageous oppression or worse of the Tatar people. It's simply not backed up by evidence. It is political. When we get statements, they're secondary ones. A further example from the UN High Commissioner's report, paragraph 163, he talks about comments from the Yalta-based NGO Almenda, and he makes serious allegations about torture and disappearance and so on. It's a very serious allegation. The footnote goes nowhere in terms of identifying the source, but the source seems to be Miss Skripnik, who is ubiquitous on the internet giving interviews. So there's no reason that she should be secret as a source. She set up Almenda, which is the other source referenced in that paragraph. So one person behind that too. She also set up the Crimean Human Rights Field Mission and the Crimean Human Rights Group, which are relied upon in various of the other reports, including the UN High Commissioner's report. Now, my learned friend rather pejoratively attacks me for attacking the reputation of august NGOs like Human Rights Watch. I don't do that in general terms, but I pointed out to this court in the Georgia case that an august human rights organization can be misled. And we saw Human Rights Watch in that case withdrawing allegations of cluster bombing by Russia because they'd been misled by people they thought were a dozen independent witnesses. So it can happen, and I do urge on the court, it's another reason why we have to look at primary evidence. I've got just one point with the court's leave to deal with, and it's still a question overhanging.
Conclude as soon as possible. Thank you.
I'll deal with it now. It's the basis for the limit in the Black Sea Fleet Agreement of 25,000 personnel, and we were asked what the basis of that was. Again, I can't say specifically because I can't say what was in Ukraine's mind, but I can infer that that was a figure that Ukraine did not regard as interfering with its control of Crimea.
Thank you. I call Mr. Lishina or Mr. Emerson. Mr. Emerson, you have the floor.
Mr. President, thank you very much. I'm just to pick up the penultimate point. I'm sorry if I understood or misunderstood Mr. Swainston to be impugning the reputation of an organisation like Human Rights Watch, and I'm glad to hear that he isn't. I wonder why, in those circumstances, he felt it necessary to impugn George Soros as the funder of the organisation, and indeed to suggest that the United Nations High Commissioner for Human Rights, the most experienced human rights monitoring organisation in the world, was doing nothing more than recycling second-hand regurgitated material when the report itself tells you the exact methodology that was being used. I think that the Soros slur tells us all we need to know. May I deal with the court's questions? Judge Prashal, I'm sure both parties are grateful for reminding all concerned that mediation is an option that is available. It's obviously not appropriate for either party to be making any kind of comments in response to a question like that in a hearing in these circumstances. I can say this, that it's right that there have been developments in terms of certain very fringe elements of the relationship in the last few days. One of them is the release of a filmmaker called Oleg Sentsov amongst the prisoner exchange that Mr. Swainston referred to. Oleg Sentsov has been in prison in Russia unlawfully for 5 years, like a lot of other people who were arrested in Russia in Crimea in the immediate aftermath of the invasion, and transferred unlawfully into Russian jails in respect of conduct before even Russia claims to have had jurisdiction over Crimea. So it's right to say that there has been some dipping the toe in the water in terms of Russia unwinding some of the consequences for one individual or a very small number of individuals, but the numbers of people who have suffered under the crushing weight of the Russian jackboot in Crimea are enormous. So that said, any compromise that ever could be reached would obviously need to be consistent with the very fundamental axioms of public international law. And as I said in the course of my main submissions, the most important, the cornerstone, without which international law would not exist, is the proposition that a state can't use force to take the sovereign territory of another state without an authorization from the Security Council. So the natural concomitant of that is that any result that might progress from this case is one which would necessarily have to involve the return of the territory of Crimea to Ukrainian effective sovereignty, because it is currently being unlawfully occupied. May I deal with Judge Sholbro's questions? First of all, are the parties inviting the court to confirm the long-standing case law on attribution, or are they suggesting, or is either party suggesting a new approach? In the pleadings, you will be aware that the Russian government has suggested a new approach. It wasn't entirely clear to me from Mr. Swainston's reply to that question where they stand on that issue now. May I deal with our position? The court's test of, first of all, effective control in Al-Skyni needs to be read in connection with the tests of attribution. And the rules are very clear. Where a subordinate local administration depends upon a contracting state for its economic, military and political support so as to amount to a relationship of dependency, then the contracting state on which the local administration is dependent for its continued existence is answerable in Strasbourg for the violations committed by the subordinate local administration. Here, we have violations committed directly by forces involved in exercising overall control on the ground, military forces of the Russian Federation, operating in conjunction with the forces of a local administration. And quite where we are now in terms of Russia's argument on this, I do not know, but in the written submissions, Russia has been driven to argue for a new direction to the interpretation and application of the Convention rules on attribution. And we say the suggestion that Mr. Swainston has made in his pleadings and floated today, that the court should take a different approach to that which is established, is flatly in conflict with this court's settled jurisprudence on the point. The effective control test was first cited in the interstate litigation between Cyprus and Turkey, and the argument that has been put forward by Mr. Swainston that a different approach derived from the ICJ case law would result in a different conclusion was expressly considered by the Grand Chamber of this court in the Katan case in 2012 and rejected. So it's not simply a question of the long-settled approach of this court's case law on attribution. It's also a decision as recently as 2012 of the Grand Chamber of this court rejecting precisely the submission that is advanced today by the party advancing it, Russia. So we'd invite your attention to that decision. Judge Sholbro's second question focuses attention on the period after the 21st or 18th of March and asks either party to say whether they are inviting the court to decide the basis. I mean, I think to some extent questions 2 and 3 of Judge Sholbro's are overlapping. They're both asking, in respect of the second period, to what extent is it right, necessary, appropriate, permissible for the court to rule on the jurisdictional basis, the juridical basis for jurisdiction. Now, of course, we're in the position where there are 2 periods on any view under consideration, because we are concerned with the period between the coup and the annexation, first of all. So logically, the court has got to address that period of time and decide whether Russia was in effective extraterritorial control at that stage. And then the court has got to decide, is this court going to stand outside the unanimous view of the international community and the United Nations and in direct conflict to it, and accord some sort of legal status to the bogus legal instruments by which Russia sought to assert its sovereignty and seeks today to assert its sovereignty over Crimea. Now, it might be said Well, the court doesn't need to decide that issue because, and this is one of the approaches that was taken in the Loisidou judgment in connection with the Turkish occupation of northern Cyprus. The court can say, well, it doesn't matter what the basis for jurisdiction is not disputed. That is one option. The problem is that the Russian Federation has denied jurisdiction in respect of any time up to its annexation, and accepts it from the moment of the annexation on the basis that this court should give recognition to the legal instruments of annexation. So it's their position which makes it inevitable that the court is going to have to determine whether it recognises those legal instruments. Because if it doesn't, then it's an extraterritorial jurisdiction all the way through. So, I mean, with the greatest of respect, you can't stick your hand in a hornet's nest and then complain when you get stung. That is the position the Russian government has taken. It's denied it had any jurisdiction in respect of a period it now says is the 18th or the 21st, I don't know which, but it now claims that it had no jurisdiction before the annexation. The uncertainty about the date of the annexation is really just an illustration of the fact that the whole thing was a transparent sham in any event as far as its legal proceedings are concerned. And thereafter, an assertion of territorial sovereignty. Now, the court's got to deal with that, I'm afraid, but the idea that that's somehow outside the court's jurisdiction is, in our submission, completely wrong. I mean, you've only got to ask yourself this question. In the Cyprus-Turkey litigation, Loisidou and others, the court did not, in the end, need to decide the lawfulness of the occupation in order to find that there was jurisdiction. It wasn't necessary to reach a ruling on the point. But it might have been. And here it is, but that's an argument for the parties to address the court on. But there are only two possible solutions at the merits stage. The court could either say, yes, we have to rule on it in order to, as Emerson says, in order to go through the process of logic about the pre- and post-annexation juridical basis for jurisdiction. We have to answer the question. Or the court might say we have to answer it for the first stage, but we could just not answer it for the second stage and say it's not in dispute. These are all options that the court will have to consider at the merit stage. But the point is, it cannot possibly be right for the Russian government at admissibility stage to be saying to this court, there's a possibility that at the merit stage you might come to the view that you are driven in the exercise of your jurisdiction to rule on the legality of our occupation. And that risk that the court might come to the conclusion that it's necessary is enough to make this an inappropriate application outside your jurisdiction. You've only got to think it through the consequences of the process of how that goes to realise that it's nonsense. Either the court will come to the conclusion that it doesn't need to rule on the point in the final decision on merits, because like the Loisidou case, it can just take Russia's concession for the second period, not for the first, obviously, but for the second. Or the court, in which case the whole objection falls away, because the court won't have done anything that Russia doesn't think it should have done. Or the court will decide that it is necessary to make that ruling, in which case plainly it's admissible for that ruling to be made, because you can't say a ruling that the court decides in due course on the merits is absolutely necessary and appropriate is one which should be foreclosed at admissibility stage. So whichever way you look at it, the case is admissible, and the jurisdictional point is an important one. But in any event, the suggestion that disputed questions of public international law are somehow none of the court's business, I think that was the way Mr. Swainston put it, none of the court's business because it's political and it's public international law and that's kind of above your pay grade, I think is the suggestion. The fact is, this court, as is well known, has frequently resolved disputed issues of public international law that have a critical bearing on the exercise of its functions. It's evolved a developed body of jurisprudence on the relationship between the Convention, which is its primary responsibility, and public international law that it forms a part of, when considering anything from diplomatic immunity to the application of international humanitarian law in a situation of armed conflict or a belligerent occupation like this one. The court has stressed its primary function is to interpret and apply the Convention, but it will always do so, as far as it can, in a manner that conforms with its understanding of the general rules of public international law, of which the Convention forms a part. So disputed issues of public international law, which arise in this case, they're in no sense outside the Court's regular jurisdiction. And it's peculiar, in a sense, that Russia is suggesting that they are, because the reality of the situation, as we would respectfully submit, is that the Court's inquiry is about the juridical basis of Article 1 jurisdiction. That's the question the Court has got to ask and answer in respect of two different periods of time. The first is disputed. The second is also disputed as to the juridical basis. And the Court is going to have to wrangle with those questions in due course. But that's not the same as saying it's setting itself up as if it were the International Court of Justice. Its focus of inquiry is on Article 1 jurisdiction, but in order to answer the Article 1 jurisdiction claim, it's got to decide whether Russia's exercising a territorial jurisdiction as the sovereign or is occupying the territory of another state, which is what is happening, as we all know. It's Russia occupying the sovereign territory of another state. That's why they were chucked out of the Council of Europe. It's why they've been the subject of sanctions from the EU. It's why they've been ostracised at the United Nations level. Everybody in this courtroom knows that's an unlawful occupation. So it may be, as you say, as one of the judges suggested, it's a dispute between two states about a territory. It's a situation of one state marching into the sovereign territory of another by force and taking it. Now, it's unfortunate that the consequence of this is some entry into the political sphere, but this Court's never been afraid to deal with political questions. How can an interstate case ever not be political? I mean, the idea that this is political and it's therefore don't worry your heads about it, it's outside your jurisdiction because it's political. It's an interstate case. All interstate cases, by definition, are political because they're disagreements between states. That's what political means. It's an absurdist position to be taking in the course of the argument, as far as we would respectfully submit. Very briefly, Judge Neuberger asked about the burden of proof. I think the point to some extent is implicit in the question. If you keep the monitors out because you need to make sure that there isn't an effective independent investigation of the crimes being committed on your watch and the lack of jurisdictional due process, then clearly it doesn't lie within the mouth of the Russian Federation to come forward and say all they've got is general material that's come from a human rights monitoring mission from the United Nations. Plainly, if you can't get in to do the investigation on the ground, there are going to be limits. But that's exactly why an interstate case supervised by this court with powers to order the production of evidence is so important. It's exactly because Russia has successfully managed to avoid the scrutiny of international human rights monitors by keeping them out, that it maintains a monopoly on the first-hand evidence. And this court, in these proceedings, has the power, and we would respectfully submit the duty, to crack that situation open and to conduct an investigation in the ordinary way, as it was done in the Georgia case, into the pattern of violations that's been committed here. Judge Neuberger's second question was directed to the Russian government, and the third question was asking about the deployment of personnel. And the same point was raised in Judge McMurdoch's question about the deployments. Those are important questions. They relate to the treaty that existed, or the treaties that existed between the two states permitting and authorising deployment. They require a sensible and detailed answer, and we would invite you to say that both parties have an opportunity to put a short submission in writing, addressing the provisions of the Convention and what they require. There is a significant difference between the parties as to the extent of permissible Russian forces. But whatever the position may be, there's no doubt there were covert movements in the month before 27th of February. And there's no doubt that there was a military coup on the 27th of February. Look at the videos, you will see it. They marched into Parliament, cut the Parliament off and put the flag on the roof, held everybody at gunpoint and changed the government. I mean, if that's not a military coup, it's hard to say what is. It bears no relationship to the popular democratic protests which resulted in the decision of President Yanukovych to flee from Kiev. Can I just deal with 2 points briefly? The first relates to that issue. The suggestion that's been floated today is that there was some constitutional breakdown. I'm sure that this court is very familiar with the events of the Euromaidan. Indeed, the Council of Europe sent the former president of this court, Judge Nicholas Bratzer, to conduct an investigation into the murderous crimes that were committed by the Birkut, the forces loyal to President Yanukovych, who shot at and killed pro-democracy protesters, hoping that they would suppress the democracy protests, but it had the opposite effect. And eventually, under cover of darkness, President Yanukovych, who at that time was trying to force Ukraine into a much closer economic union with Russia, left by helicopter and has been taken refuge in Russia ever since. In the course of those protests, scores of demonstrators were the victims of live round ammunition fired by the Birkut forces, who then made up the CSDF paramilitaries in Crimea, same forces that shot the protesters in Euromaidan, side by side with the Russian forces taking control in Crimea. It's true that it has some background political relevance. Its background political relevance is that it was considered a humiliation by President Putin and of President Putin when President Yanukovych effectively was forced from power by the groundswell of democratic process. A humiliation and something that definitely couldn't be allowed to happen in Russia. And so the crucial step was that the people of Ukraine had to be taught a lesson. They had to pay a heavy price for their audacity in daring to aspire for a future at the heart of the democratic institutions of Europe and out of the sphere of influence of Russia. And so Crimea, part of their sovereign territory, would be ripped away from the country by force as the price that had to be paid, together with the destabilisation of Donbass through the downing of civilian aircraft by Russian-sponsored separatists, in which he wants to bring in the events in Ukraine. Let's talk about the deliberate targeting of MH17 and the 170 passengers on board that were killed. It's another case, but since that seems to be the course that's being adopted. The point I'm making here, and I think it's obvious to everybody in the courtroom, is that this was retribution for a democratic government, a democratic movement in the Euromaidan, which resulted in a change of administration. And Putin was humiliated, but above all, the people of Ukraine had to be taught a lesson as to what the cost of democracy would be if they tried to move away from the Russian sphere of influence. And that is precisely why the military coup was conducted, and it's precisely why those who remain loyal to Ukraine have been systematically targeted by Mr. Swainston's clients from the beginning for human rights violations that are going on today with no proper system of accountability. And that's why it's this court's job to do a proper exercise, getting behind the wall that the Russian government has tried to put up to shield itself from accountability and to conduct a proper examination of the facts on the merits. Thank you.
Thank you very much. Now I turn to the judges of the Grand Chamber who may wish to ask for further clarifications related to the questions they asked, if any. No new questions, please. Yeah. Okay. Since this is not the case, we have now come to the end of the hearing. I thank the parties for their submissions and answers to the Court's questions. The Court will now deliberate on the admissibility. A decision on the case will be adopted later. I declare the hearing closed.